The House is resumed for the extended sitting. I call on Government Orders of the Day, numbers 8 and 9.
Te Urewera Tuhoe Bill, Committee Stage. Ngā Mana Whenua o Tāmaki Makaurau Collective Redress Bill, Committee Stage.
I declare the House in committee for consideration of the Te Urewera Tuhoe Bill and the Ngā Mana Whenua o Tāmaki Makaurau Collective Redress Bill. Mr. Chairman.
Mr. Speaker. Members, the House and Committee on the Te Urewera Tuhoe Bill and the Ngā Mana Whenua o Tāmaki Makaurau Collective Redress Bill, and we come first to the Te Urewera Tuhoe Bill.
Mr. Chairman.
Honourable Chris Finlayson.
Mr. Chairman, I seek leave for there to be one debate on the bill with questions put separately at the conclusion of the debate.
Leave is sought for that purpose. Is there anyone opposed to that course of action? There appears not. Leave is granted. So the question is that parts 1, 2, 3, 4, 5, 6 and 7 in the schedules stand part.
Mr. Chairman.
Honourable Chris Finlayson.
Thank you, sir. I'll just say a few things about the overall structure of the bill and then talk in particular about the longer SOP, because it raises a number of matters that the Select Committee were concerned about. The first point is that this will divide into two bills. Parts 1 to 4 will be the settlement bill, and parts 5 to 7 will be the bill dealing with the governance and the status of Te Urewera. Can I say something, please, about the SOP number 468? Because that deals with two matters that need, the first matter needs to be brought to the attention of the committee, and then I want to say something about a recent High Court decision. The first is the issue of the Central North Island Forest cultural redress sites, and two have been added to the list of those sites, Waitatuhi and Korokoro o Te Huatahi. Under the CNI deed, the Crown has the right to vest cultural redress sites in CNI iwi, and in this case Ngāi Tuhoe have followed the same process as Ngāti Manawa, Ngāti Whare and Te Arawa in seeking CNI cultural redress sites as part of their treaty settlements. The sites that Tuhoe seek are not in the same location as the sites in which Ngāti Manawa has interests, and rentals from the sites, as I understand it, are going to be used by Ngāi Tuhoe to benefit Kaingaroa village communities. The vesting of the sites in Ngāi Tuhoe is obviously without prejudice to the CNI Mana Whenua allocation work, which is a work in progress as we speak. The second thing I want to say is just something very briefly about a recent decision of Justice Williams in the High Court, and that concerned an application for judicial review of a decision of the Waitangi Tribunal, and it involved Ngāti Ruapani and Te Pukorehe. Mr. Chair, the area of interest described in the Ngāi Tuhoe deed of settlement does not represent an area of exclusive interest or tribal boundaries. The deed is very clear that other iwi, hapu, will or may have interests in those areas. Ngāi Tuhoe has customary interests at Ohiwa Harbour, and because of this, quite a long time ago now, in terms of the Maori Fisheries Act 2004, they were allocated fishing quota under that legislation. The land to be transferred to the new Te Urewera identity is currently part of the Te Urewera National Park. It will be owned by Te Urewera and not Tuhoe. The Tribunal declined the Te Upukariki applications for an urgent hearing on the basis that they would not suffer prejudice from the Tuhoe settlement. And the High Court, Justice Williams, recently found that while there was a technical jurisdictional error in the tribunal decision not to grant an urgent hearing of Ngāti Ruapani and the Te Upukarehi claims, the tribunal was correct in finding there was no substantive prejudice caused by the Crown's settlement with Ngāi Tuhoe. So the point I want to emphasise is that there is nothing in this settlement that will prevent the Crown from engaging with Whakatauia, or its hapu, or Ngāti Ruapani when they get a mandate, and achieving a just and a durable settlement of their historic claims. And to suggest otherwise is wrong. There are areas of interest, and the Crown is able to achieve just and durable settlements in the circumstances that I have described. So the other key points that I wanted to raise this morning, as I say, one arising out of the SOP, and secondly, because of the recent decision of the High Court, I thought it appropriate to bring to the attention, Mr Chair,
Honourable Chris Finlayson.
Bring to the attention of the committee the decision and its effect.
Honourable Nanaia Mahuta.
Tēnā koe, Mr Chair. I want to speak in favour of the SOPs on behalf of Labour as introduced, with the clarifications that the Minister has provided, but